So you just got that terrifying letter from the IRS, a Notice of Deficiency, also called a 90-day letter, saying that you owe tens or hundreds of thousands of dollars in additional taxes. And now you're wondering, can I really take the IRS to court by myself? Do I actually need to hire an expensive attorney? I'm Andrew Bosserman, former IRS agent and founder and tax attorney at Boss Tax Law. Here's the truth. Yes, you absolutely can represent yourself in tax court. You have that right, but whether you should is a completely different question. In this video, I'm going to show you exactly how to take your case to tax court without a lawyer, walk you through the real process, and then explain 3 critical reasons why going pro se, and that's legal speak for representing yourself, might cost you far more than hiring representation in the first place. So let's get into it. First, I just want to be crystal clear. You have an absolute right to represent yourself in United States tax court. Tax court explicitly allows pro se representation. In fact, over half of all taxpayers who petition tax court do so without an attorney. So yes, you definitely can do this yourself. Tax court even has resources specifically designed to help pro se taxpayers navigate the process. And here's what the process actually looks like. You'll need to file a proper tax court petition within 90 days of the date on your notice of deficiency, pay the filing fee, make sure the petition gets served on the IRS, potentially navigate discovery requests from IRS attorneys and exchange documents, present evidence and examine witnesses. That goes to trials and hearings, make legal arguments about tax law, and before that, you might even have settlement discussions with IRS appeals and IRS attorneys. Tax court will treat you as if you were an attorney. The judges are generally patient with pro se taxpayers, but they're not going to give you legal advice, and you're still expected to follow certain court rules and procedures. Here's a little bit more detail about what happens if you decide to go it alone. So the first step is filing your petition. So this part is critical. You have exactly 90 days from the date on your notice of deficiency to file your petition with tax court. Miss this deadline by even 1 day and you lose your right to challenge the IRS assessment before you pay. That assessment becomes final, and now you're looking at collection action, which could result in liens, levies, wage garnishments, and other collection actions like that. The petition itself is actually not that complicated. Tax court has a form you can use, and it's on their website at ustaxcourt.gov. You'll need to include basic information, your name, the tax years in dispute, and the amounts the IRS claims you owe. And you also need to state why you disagree with the IRS's determination. So after you complete and file the petition, the IRS Office of Chief Counsel, and these are IRS attorneys, not the agents who examined you, will file an answer to your petition. They'll admit or deny each allegation you made and may raise their own legal arguments. After the answer is filed, oftentimes your case is sent to IRS appeals for settlement discussions. If you haven't had a chance to go before IRS appeals before, the case will get sent there and you will work with an appeals officer to discuss your case, present documents and arguments, and try to settle your case before it goes to trial. And settlement discussions are actually the part where attorneys become most valuable other than trial, but we'll get to that. If you're unable to come to a settlement agreement with an appeals officer, then discovery and trial preparation starts. And this is really where it starts getting real. Discovery is the process where both sides exchange evidence and information. Tax court has fairly informal discovery processes to exchange information, but there can also be very formal discovery. And these are things like interrogatories, which are written questions you must answer under oath, requests for production, which are demanding you provide certain documents, and requests for admission, asking you to admit or deny specific facts. If you are served these formal discovery requests, you need to respond to all of these properly and on time. If you don't, the court can sanction you and it can cause other issues with your case. Finally, if you're unable to settle with either IRS appeals or with the IRS attorneys, you're going to trial. And if you go to trial, you're going to need to present opening statements, introduce evidence, examine and cross-examine witnesses, make legal arguments and cite to the proper law, and present closing arguments. And regardless of if you go alone, the IRS will have an experienced trial attorney doing all of this against you. So now here's why I'm telling you that just because you can represent yourself, and I just laid out how you could, doesn't mean you should. So the first reason is that the IRS has professional advantages you just can't match. The IRS attorneys assigned to your case, they went to law school, they passed the bar exam, and they represent the IRS in dozens or even hundreds of tax court cases every year. They know the judges, they know the law, they know the procedures, they know the strategies that work and the arguments that fail. You're learning as you go with potentially hundreds of thousands of dollars on the line. It's like you going up against a professional athlete. They just have advantages by being on the court or in the ring every day that oftentimes you just can't match because you don't have that experience and knowledge. Reason number 2, tax court judges won't help you. So I want to be very clear about this because oftentimes pro se taxpayers are confused about this. Tax court judges are extremely smart, fair, and often patient with self-represented taxpayers, but they are not your advocates. They're not going to tell you what evidence you need to win, explain why your legal arguments are wrong, guide you on what questions to ask witnesses, warn you that you're about to waive important rights. Their job is to be neutral. If you don't know the rules of evidence, you can't properly introduce a document, if you don't understand burden of proof or what substantiation requirements apply to your situation, that's your problem, not the court's, and the judge is a neutral arbiter, not someone on your side. Reason number 3, the real cost of going pro se, and here's the math that most people don't consider. So let's say the IRS claims you owe $200,000 in additional taxes. You think a tax attorney is going to charge me $25,000 or $50,000 or possibly even more. I'll just do this myself and save that money. But here's what actually happens. If you go pro se and lose completely, you pay the full $200,000 plus interest and potentially penalties. If you go pro se and say you settle, but you settle poorly because you don't understand negotiation leverage points, maybe you pay $150,000. But if you hire a qualified tax attorney who knows the case law, understands IRS settlement procedures, and can properly present your evidence and make compelling arguments, maybe you settle for $50,000 or $75,000 and you win completely because you pay even less, including the attorney's fees, than you would have if you won it alone. Now, this is an example scenario, but oftentimes I see that the attorney's fee doesn't cost you money. In fact, it oftentimes saves you money when you take everything into consideration. And another thing you want to avoid is starting pro se, making mistakes, and then hiring an attorney later. You might actually end up paying that attorney more to fix the problems you created than you would have if you hired them from the beginning. Now, I'm not saying there's never a situation where representing yourself makes sense. There are a few scenarios where going pro se might make sense for your situation. So the first is if you have a very small case, maybe $5,000 or $10,000 in dispute, and where the cost of representation just doesn't make economic sense. Scenario number 2, maybe you have a purely legal issue with very clear facts and you're extremely comfortable doing legal research and writing. Even here, though, you're oftentimes taking a significant risk But if you are comfortable with legal research and writing, you might be able to get by. Third, you're using it as a negotiation tactic. So some taxpayers file a pro se petition to meet the 90-day deadline. Maybe they're running right up against that deadline, and then immediately hire an attorney to handle settlement negotiations with appeals. This can work, but timing is everything, and it helps to get a tax attorney involved as soon as possible, including filing the petition, because you don't want to make any mistakes in filing the petition. For everyone else, especially if you're a business owner with significant amounts at stake, or if you have complex factual issues, or if the IRS is alleging fraud or substantial penalties, professional representation is a strategic necessary. So, look, I get it. Nobody wants to spend money on legal fees, but tax court isn't the same as just going to small claims court over a fender bender. This is the IRS, the federal government, backed by essentially infinite resources and experienced attorneys coming after your money and potentially your business. You have every legal right to represent yourself, but just because you can doesn't mean you should. Before you make that decision, at least talk to a qualified tax attorney. Most of us, and myself at Boss Tax Law, we offer consultations where we evaluate your case, explain your realistic options, and give you an honest assessment of what representation would cost versus what you stand to gain or lose. So if you've received a notice of deficiency and you're not sure what to do next, reach out to Boss Tax Law. We handle tax court cases throughout the country, and I'd be happy to review your situation and explain your best path forward. So don't let that 90-day deadline pass while you're trying to figure this out on your own. That's one mistake you can't fix. So thanks very much for watching, and I'll see you in the next video.